हेलो स्टूडेंट्स, वेलकम टू माय यूट्यूब चैनल शॉर्टहैंड सॉफ्टवेयर। अब जो मैं डिक्टेशन बोलने जा रहा हूँ उसको आप मेरे एग्ज़ाम बेस्ड स्टेनो ऑनलाइन सॉफ्टवेयर पर ट्रांसक्रिप्शन करके अपनी एक्यूरेट मिस्टेक चेक कर सकते हैं। इस मैटर का पीडीएफ और एडवांस आउटलाइन आप हमारे टेलीग्राम ग्रुप से ले सकते हैं, जिसका लिंक मैंने डिस्क्रिप्शन में दे रखा है। 3, 2, 1 start. The petition is filed by the insurance company, insurer of a truck which collided with a motorbike, leading to fatal injuries to the bike rider. Stop. The wife and mother of the deceased filed the claim petition, in which, the tribunal, while making the award, found contributory negligence on the deceased. Stop. The liability of the award amounts on the insurer of the truck was apportioned at 50%. Stop. The claimants and the insurer filed appeals before the High Court. Stop. The High Court found negligence solely on the part of the driver of the truck and enhanced the award amounts, against which the instant petition is filed. Stop. Para. The learned counsel for the insurance company argued that this was a unique case in which the driver of the alleged offending vehicle mounted the box and spoke of the accident, which deposition indicates negligence on the bike rider. Stop. This is amply supported by the officer who investigated the crime. Stop. The interested testimony of the eyewitness, who was admitted to be the friend of the deceased, should be eschewed, considering the overwhelming evidence of negligence on the part of the bike rider. Stop. Para. The learned counsel for the respondent, numbers 1 and 2, seeks to uphold the judgment of the High Court, which reversed the order of contributory negligence passed by the tribunal. Stop. The learned counsel also justifies the enhancement made relying on precedents. Stop. Para. The reliance placed is on the driver of the offending vehicle, the truck, who was examined as RW1, and the investigating officer who was examined as RW3. Stop. RW1 mounted the box and his deposition was to the effect that there was no collision at all and the case was filed against him only because he was driving a bigger vehicle. Stop. However, the evidence of RW3, investigating officer was contrary to the extent of admitting the collision between the bike and the truck. Stop. His evidence was that there was contributory negligence on both the drivers on an assessment of the lie of the vehicles at the accident site. Stop. Para. But, in cross-examination, he admitted that the position of the motorcycle could have been changed by the time he reached the spot. Stop. It is also very pertinent that the deposition of RW3 about the negligence of bike driver conflicting with the charge sheet filed by him against the truck driver. Stop. His explanation was also that the charge sheet was filed against the truck driver since the motorcycle driver had died in the accident. Stop. We are unable to countenance the said statements of the investigating officer, who was examined on behalf of the respondent before the claims tribunal. Stop. Para. The evidence of the eyewitness, PW3, was that he was accompanying the deceased in another bike. Stop. They were proceeding to a common destination on two bikes, PW3 following the bike of the deceased. Stop. He specifically spoke of both the bikes being driven in normal speed when the offending truck came through the wrong side and hit the bike of the deceased. Stop. He has also deposed that the truck was driven in a rash and negligent manner. Stop.